Welcome to the Herlihy Family Law Podcast, your trusted source for expert insights on navigating family law matters with clarity and care. Whether you're tackling tough decisions or seeking guidance for your family's future, we're here to help. Let's get started.
Welcome back to the Herlihy Family Law Podcast. I'm your host, Alison Herlihy, and as always, I'm glad you're here. I'm joined by criminal defense attorney Maxine Walters, who practices right here in Mobile. Maxine and I are talking about where family law and criminal law intersect, because in real life, those lines are often blurred. From domestic situations that carry both civil and criminal consequences to how criminal charges can impact custody, divorce, and a family's future. This is an important conversation for anyone navigating the legal system. Maxine, welcome. Thanks for being here.
Thanks for having me. I'm excited to be part of this conversation.
Yeah. Can you briefly describe your criminal defense practice and the areas that you handle day to day?
Yes, I handle criminal defense matters here in Mobile and South Alabama, and I usually handle misdemeanors and felonies in municipal, state, or federal court. And a lot of them actually come out of domestic or family situations. That includes domestic violence charges, violation of protection orders, and other offenses related to those. I also do some expungement under Alabama law, and that can also be really helpful for both parents and professionals.
Great. So in family law, we deal with divorce, child custody, child support, but sometimes those matters touch criminal issues. So what are some areas where our practices overlap? Let's talk about that. You mentioned domestic violence. That's obvious.
Yes, we did talk about that. Some of it is also like no contact orders or violating the protection of abuse orders. Some of it is harassment or stalking allegations, violating court orders. And some of this can also stem from conduct that occurs during a separation, which may be threats, interfering with custody, or using technology to do those threats, or tracking someone, things like that. All of those things can lead to potential criminal charges.
Yeah. One thing you mentioned in particular that I think is important to note, we've all heard of some people call them restraining orders, but under the law, it's called a protection from abuse order, or a PFA. And I think a lot of people don't understand that violating that in and of itself is a crime. It's a separate crime, right?
Yes, and it can also be even beyond your protection from abuse order. There can also be conditions of your bond if there is certain conduct that leads to criminal charges, where there can be not only no contact orders, but no violent contact orders. And if someone were to violate those, they can risk losing their bond and being held in custody while their case is pending.
So that means let's just kind of break it down. If somebody gets arrested for domestic violence against their spouse and the judge says, okay, I'm going to let you out on bond and you cannot contact your spouse, right? That's what a no contact order would mean. If they violate that order by contacting the spouse, when you say held in custody, that means they can be put in jail until their criminal case is over, right?
Yes, that's correct. So normally, if there is an allegation of that, either the alleged victim in the case or someone else will reach out to the district attorney and they will file a motion to revoke your bond. And then there will be a hearing on that for the judge to determine if you violated that condition of your bond or not. Now, sometimes there will be no violent contact when they know that there are pending custody arrangements or current custody arrangements with shared children. But if that is violated, then they can revoke your bond, which, yes, would mean that that person is in custody in jail until either that's reconsidered or until their case goes to trial or settles in a different way.
Yeah. So you mentioned if there's no violent contact, that might be a situation where people have children in common and obviously they have to speak about the kids or see each other when they exchange the kids and things like that, right?
Yes, and another important thing is this can also include third parties, and it doesn't always have to be person-to-person contact. So if you're telling, someone to deliver that person a message, that can be considered a violation. Or if you are sending things through text or social media directed at that person, that can also be considered a violation. So it's very important not to think of it in a literal sense, but also the fact that it can be through other mediums, such as other people.
That's really good to know. Well, yeah, I mean, domestic violence is a big area where these areas of the law overlap. When someone is facing a criminal charge in this space, what should the family know? I guess let's start with if what should the person that's been arrested know? What do they need to know?
So I think they should know first that those conditions may be put in place, such as no contact or no violent contact, far before a conviction. So I think a lot of times people think that there's no sort of direct effect until you had your day in court, but that's not necessarily the case. Usually these conditions are put up front, and then they may be lifted later. But just because that happens doesn't necessarily mean you're guilty of an offense. But usually they will happen either at your bond hearing. So your bond hearing will usually be your first hearing after you've been arrested, and that's when these conditions would be put in place. A lot of times that's why you may not be able to waive your arraignment if it's a domestic violence case, because they want to verbally give you that no contact order at your bond hearing. And so those conditions may last while the case is pending, and sometimes that could be several years.
So is several years a typical time frame for a domestic violence case to get resolved?
So it depends on if it's a misdemeanor or a felony. If it's a misdemeanor, it's usually a bit of a shorter time, unless there's an appeal, because you would have a bench trial. But usually you'll get arrested and you'll have your bond hearing within, if not the next day, within a couple of days. And then you'll have your arraignment, usually the next week or so. And then you should have what's called either a preliminary hearing or a bench trial. I don't want to get too technical, but if you're having a misdemeanor, you'll have a bench trial, and should you be convicted, you can appeal to a jury trial. But if it's a felony, like a DV strangulation, then you'll have a preliminary hearing to see if there's probable cause to send it to the grand jury, which usually takes somewhere between 6 to 12 months. And then after that, you would then go to circuit court, where you'd either resolve the case or have a jury trial. So I'd say if it's a felony, it usually can take somewhere between over a year to 2 to 3 years, just depending on how backlogged the system is.
Wow, that's a long time. I'm glad that you mentioned the strangulation issue particularly, because that's something that we've seen come up in several cases. And I think a lot of people out there, like, it may not be common knowledge that strangulation is a separate offense that is a felony, right?
Yes.
Yeah.
A lot of times that the difference between the two will be if there's either some type of bruising or something that the officer or is photographed, or if there's an allegation of that will automatically be a felony, whereas otherwise the charge may have been considered as a misdemeanor.
Yeah. And I understand a little bit of the legislative motivation behind that is because strangulation is like the most lethal form of domestic violence, which is why they felt the need to escalate that to a felony, right?
Yes.
Yeah. So, okay, we talked about what do you need to know if you're the one that's arrested. What if you are the victim of domestic violence? What does that person need to know if they're trying to navigate the criminal system and protect their rights?
So a couple of things they should know is it may be a lengthy process. So this is something that, usually people will come to court for trial, but there may be other court dates that they want to be informed of or want to attend prior to the trial date. And so that would require being in contact with the district attorney's office, or if it's a municipal case, with the city attorney's office, just so that you're aware of when those court dates are, if you would like to show up, even if you're not subpoenaed. And letting them know how you feel about the disposition of the case. I know a lot of times the prosecutors will reach out and ask if agree with a certain plea offer, even though that's not always the final decision. They will take your opinion into account if you share it with them, if they're able to get in touch with you. So definitely would have your contact information up to date. Ask if you'd like to be informed of different court dates, but also be aware that you also, if there's a no contact order, are not supposed to contact them. I know most of the time it usually will be held against the defendant if the defendant reaches out, but the defendant can also let their attorney know, hey, even though I'm not reaching out to this person, they're constantly messaging me, and that may not look good to the judge or the prosecutor as well. If someone can't contact you, but you're constantly, contacting them, not related to children.
Yeah, I mean, it makes it a little hard to claim that you're afraid of somebody if you're contacting them all the time, right?
Right.
Another crime that we see a lot in our cases, a lot of people get arrested for DUIs, and part of why I wanted you to come on this month is because we're in the middle of the Mardi Gras season, and there's a lot of drinking and driving going on. So, what like tips do you have for somebody if they're facing a DUI? What does that look like?
A lot of people don't know that you can actually refuse not only the breathalyzer, but the field sobriety test. Those tests may or may not impact if they're, going to take you to jail or not. Sometimes if you take them, you may still go to jail and get arrested. So it may not always be helpful. So I would potentially advise against that, but know that you may have a suspension of your driver's license. So refusing to take the breathalyzer will usually result in an administrative suspension of your driver's license through ALEA in Montgomery. And so you can decide not to take it, but know that may be a consequence. Now you can try to appeal that, but also be aware that, if you've got to work and things like that, it may put you in a difficult situation if you refuse that breathalyzer, and then you've got to figure out another way to get around while your license is suspended for those few months.
Yeah. But if you do take the breathalyzer and you've been drinking and you fail it, basically you're helping the prosecution convict you, right?
Yes. They've got to meet their burden to show that you are unable to safely operate a motor vehicle. And so if you are providing them with that evidence by, with your field sobriety test, such as you not being able to, walk stably or do the one leg stand and all those different tests, or if you are giving them the evidence of your blood alcohol content, that also will hurt your case later.
So Maxine, what does the time frame look like to get a DUI resolved?
So normally it's a little bit shorter than a felony, since you would usually have a bench trial instead of a jury trial. So I would say that one usually somewhere within 6 months. However, it would be important to note that if there is an issue with how long it takes to get body cam from an officer to the prosecutor to be shared with the defendant and the defense attorney, then that may take a little bit longer. I've seen sometimes it take months to get body cam, or depending on the city or county, you may have to pay for that request and pay for any documents by the page number. But usually within 6 months, you'll have a bench trial on your DUI. And then if you lose that, you can appeal it and request a jury trial.
Okay. And I know this is not my area, so correct me if I'm wrong, but I understand the law now is that on a first conviction for a DUI, you get an interlock device in your car. Is that right?
Did that change recently? I need to look and see. I know there are definitely enhanced penalties for both subsequent convictions and also alcohol levels above 0.15. I've definitely seen those. And then if you have a CDL, but I haven't been up to date on any new updates regarding the first conviction.
It may be a law that's like in the legislature now that's pending.
Okay, I'll definitely look into that.
Yeah. And yeah, you mentioned CDL, like people with a commercial driver's license, the blood alcohol level cutoff is actually lower if you have a CDL, right? Yeah.
Yes, and you also are not eligible for certain diversion programs, and then you also, upon conviction, risk losing that and having to wait a period of time before you can try to get your CDL again. Yeah. So that affects a lot of people's livelihood as well.
So there's a lot at stake there. So don't drink and drive, folks.
Right.
Well, one last specific crime I wanted to ask you about is this is kind of like a hot topic that comes up a lot for us in our cases now is using technology to surveil people. So people planting trackers on people's vehicles or air tags or in their personal items and that kind of stuff. Can you explain a little bit about where you might run afoul of the law if you're doing that kind of thing?
Yes. So I've definitely represented folks on that before. I believe there's been some recent updates to the law, but even a few years ago, it was definitely a felony. So you definitely want to avoid that. And I believe that was use of an eavesdropping device. So the issue there was being able to record someone without their consent. And I think it also, you can't have, so it's kind of hard because I know a lot of people these days have given permission or have like these family location apps. I'm not seeing it as much with that as I am with leaving something within someone's vehicle and then, them not knowing, and then you're also not there. So it's not like it's your location, you're with them. It was,
Right.
the case I had was a device under someone's vehicle, and then they heard something that someone else said, and then called the police, and then they ended up going to jail because they were not allowed to have placed that device on another individual's car because it could, because of the eavesdropping component of the device as well.
Yeah. So
I'm not sure.
if you put a tracker or recording device in somebody else's car, that's a crime.
Yes.
Yeah. It seems like that kind of turns on the issue of consent. So like if you both consented to share your locations on like Find My iPhone or whatever, I mean, obviously that's not a crime because you are all agreeing to do it. Right. And I know too, isn't it correct that in Alabama, you're allowed to record your own conversations with others?
Yes.
Right. But
yes. You just need one party consent.
Right. So you can't record your spouse talking to somebody else, but you can record your own conversations with your spouse, right?
Yes.
Yeah. That's really important information to know. The technology's out there and everywhere, but nobody's there to explain to you if what you're doing is illegal or not, until it's too late sometimes. Well, let's talk a little bit about how criminal protective orders differ from civil protective orders. So we kind of touched on like the no contact order versus a protection order, right?
Yes.
And then like in a domestic relations case, in a divorce, a judge can enter an order saying like, you're not to harass, stalk, assault, et cetera, the person. I would call that basically a civil restraining order. And I think the important distinction there is if you violate that order, the remedy is you have to file a motion for contempt in front of the judge that issued it. But violating that order is not a crime. Whereas
Correct.
Violating a PFA, petition from a protection from abuse order, that is a separate crime. So that's really important to know, right?
Yes.
What are some common misperceptions people have about how criminal charges can affect custody or divorce outcomes?
So I think one big,
like that?
Yes. I think some people assume that if you're arrested, then that automatically determines a custody outcome or, child support issues, things like that. The family court goes on a separate standard, which is the best interest of the child, not 100% based on if someone's accused of a crime or misdemeanor or felony or not.
Right.
And the other thing is people aren't always aware that things that they say in family court can hurt them in a criminal case. And so if you right, testimony and things like that come out in family court can be used in criminal court.
So along those lines, something we see a lot, especially if somebody gets arrested for like a serious crime while their divorce is pending, what often happens is their divorce case ends up being stayed or like, I know but put on hold, on pause until the criminal case is over with, because people have a Fifth Amendment right against self-incrimination. So being made to testify in your divorce case is potentially a violation of your Fifth Amendment rights, right?
Yes.
Yeah.
That's definitely the case. And with a lot of other civil cases as well will be stayed. Like even if they take money from you, you can't fight over the money until you determine the criminal case.
Yeah. Do you think that that's the safest course of action if somebody has a criminal charge, that they want their divorce case stayed until the criminal case is over with?
Yes, you definitely don't want to self-incriminate and have sworn statements that can be used against you in your criminal trial by doing your family trial. So you want that stayed.
Yeah. And so the sworn statements would include not only testifying in open court, but things like answering interrogatory questions in discovery, because those are written sworn statements, right?
Right.
Yeah. Yeah, I think that was a good point that you made earlier about that best interest is what's really important here, because I do think a lot of people think that if someone gets arrested, well, I think a lot of people think if you get arrested, it automatically means you're guilty, which is not the case, you know. But I do think a lot of people think if someone has a crime going on while their divorce is pending, that it automatically means that they're going to lose custody. But there's a lot of other factors that the court looks at. I mean, I can think of a case I was involved in kind of recently as a guardian ad litem for the child. And one of the parents did get a DUI while the case was pending, but that parent ultimately got custody of the child because the court concluded that there were a lot of other reasons why that parent was a better fit to have custody despite their DUI. Now, that being said, like the person that got the DUI quit drinking. They didn't have the child with them when that happened. The child was with the other parent, you know, so it wasn't in a way that endangered the child. But I mean, I would say like if you got a DUI with your child in the car, your custody case is over. Probably, you know, unless the other parent is way, way worse than you, because then it's at a point that's not just like, okay, I made a poor decision that maybe endangered myself or other drivers on the road. But if your child is involved in that, then you're directly harming the child. And that's an important distinction, I think.
Right. I think so too. Sometimes people also use the court system to kind of, you know, negotiate. I've also seen it where, you know, someone says, well, if I get the kids for Christmas, I won't show up to court on this domestic violence case. I feel like
right. Yeah.
You know, use the system that way as well.
And, you know, I've had that come up where I've had cases where on either side where I've represented like the person with the charge or the person who's the purported victim. And one side or the other says like, okay, we can settle the divorce, but I want it to say in the divorce that the criminal charge is going to be dropped. And I think a lot of clients don't understand that it's an ethical violation for a lawyer to use the threat of prosecution to try to gain advantage in a civil case. So it may seem to make a lot of sense that, like, of course, you want that written down on paper because you want it guaranteed, right? But that would be unethical for your lawyer to put that in your divorce agreement, in my view. Yeah. So let's talk about the expungement. You mentioned expungement earlier. Can you explain a little bit about what that is exactly and how it can help people?
Yes. So it's basically removing something from your criminal record in terms of like when you apply for jobs and you're doing a background search and that kind of thing. So usually in Alabama, if you're going to have unless you're a victim of human trafficking or a few exceptions, it's going to be mostly misdemeanor convictions or felonies or misdemeanors that were later dropped or went through some sort of diversion program or were null pros, dismissed null pros. Those are usually what will be eligible for expungement. So with misdemeanors,
if I could just jump in, like say somebody has like a first time domestic violence arrest or like a first time DUI, and they work out an agreement where they're put on like good behavior for 6 months and they do some, you know, batterer intervention classes or DUI school and do probation. And then at the end, they don't get in trouble. They do what they're supposed to do. And the charge gets null pros or dismissed, right?
Yes.
So those people would be eligible for an expungement. Isn't that right?
Yes. The timing depends on whether it was null pros or dismissed. Of course, all your conditions have to be met and your court costs and any fines have to be paid. But usually it's shorter. So it can be anywhere from 90 days to a year if your case has been dismissed. If it's a misdemeanor conviction, it'll be 3 years. And then if it's a felony, you actually have to get a pardon. And then you can apply after you get the pardon and all your other conditions are met as well. And I believe it's a certain number of years, but it's a lot more lengthy and difficult for felonies. Generally much easier if your case has either been dismissed or if you had a misdemeanor conviction.
So how can expungement benefit people? So
it can help them by their prior convictions not showing up on their background checks. It can help with licensing. I know a lot of people are trying to get, their like nursing license or things like that. It will help with that. Getting things removed from your driving record. Those convictions for DUI and things like that will help you, say if like you're trying to get your CDL. So it can definitely help you. Now the process itself usually takes somewhere between 3 to 6 months. So I do try to tell people when they call and ask about expungement, it's not overnight. So a lot of people already have a job in mind and they want to apply for that job, but they're not always aware that once we get that filed, which requires getting paperwork not only from the court but also from the state, that the government will have 45 days to object. So from there, the judge may either grant or deny the motion or set it for hearing. And so sometimes your hearing date may be further than you expected as well, based on the court's availability. So I usually tell people somewhere between 3 to 6 months. But I've also had it where sometimes there was one hearing date set and then they reset it. So then it went out longer. So I tell them to try to get it as soon as they're eligible instead of waiting for, they want to apply for a certain job opportunity.
Right.
And get
like you've got a job offer and they say, okay, we just have to do a background check. You need to apply way before that. Right.
Right.
Yeah. Well, one other thing that family law and criminal law have in common is you work with clients that are in highly emotional states, because it's high stakes things. It's your children, it's your freedom, it's your life. How do you balance legal strategy with empathy for your clients?
So I would say that I try to have empathy because I know, like you said, it's usually people's worst day or one of the not so great things that have happened to them when they call me or meet with me. But I also try to be very clear and honest so that I can help them set their expectations in a reasonable way, but so that we can also have our strategy together, because a lot of things are about coming to a conclusion that both parties can be happy with. And sometimes there are things that the other side may not be aware of. Having a conversation with them can also clear up certain issues and just set realistic timelines about everything, not only on potential outcomes, but even on the timeline. A lot of people are really disappointed to hear that they may have to be coming to court for, more than a year. They think, I'm innocent. I'm going to get my case over. It's going to be thrown out in the next couple of months. Well, we may have a court date, 2 years from now. But before I forget, one thing about expungement I wanted to point out is there are a lot of offenses that are not eligible. So not every misdemeanor will be eligible. And even some felonies that you may encounter, like if it is certain more serious offenses, certain sex offenses, like vehicular homicide, things like that. A lot of them are not going to be eligible for expungement. And so that's another thing to consider. And on top of that, eligibility doesn't always mean it's granted. Sometimes the judge may decide based on their discretion that they don't want to expunge it based on the underlying facts of the case. So I do want to let people know that it's not a guaranteed automatic process, but it's very dependent on the statute, which changes because it changed recently. So there is potential it will change again, but that's up to the legislature.
Yeah. So you've really got to stay on top of all those ongoing changes with criminal law.
Yes, I think it was 2021 that it changed recently.
Okay. Well, say you have a client who has a pending like DV charge or harassment charge with their spouse or their ex-spouse or their person that they have a child in common with. And they do have to communicate with them about some things like we talked about earlier. Maybe they have an order that says no violent contact, but they've got to text them sometimes about like, Johnny and Susie's soccer practice or like getting the mortgage paid on the house or the things they have to talk about. What advice would you give to those clients about communication and decision-making when they're under stress, but like the stakes are high because they've got relevant criminal charges?
So I would say, I know it can be awkward, but try to do as much as you can in writing just so that there's not, any dispute later as to what was said, or maybe, somebody may have motivation, even if there was a third party there to side with one person or the other. Try to get as much in writing. I do believe there are centers, and you probably have a lot more experience with this, where you can actually have the kids take them there, and then the other parent will to do custody transfers. But I would say get as much as you can, do it in writing, just so that there's a safety net, especially when it comes to no contact orders. I think that's the biggest thing. But also just, if you can, if it's not immediate, kind of take a deep breath and walk away from it for a little bit and then come back to it, just so that, emotions aren't still tense when you do finally get around to communicating with the person. I know everything isn't always in writing, but at least that way, you've had a second to decompress.
Yeah. Well, and it's great to have it in writing, because then there's no question about who said what and when, and I mean, I always tell clients too, you need to play the long game. You're upset, you're stressed out, so it may feel good right this second to pop off at somebody, but you need to think about yourself in next week or next month or next year, and is saying that right now going to help future you? You need to play the long game and think about those consequences of your actions. Because, when your emotions are really high, it's easy to forget that all the actions have consequences.
Right. And especially when it comes to social media, I know a lot of times people will air out their frustration on social media. that will not
stay
help.
Off it. It cannot, it's never going to help you. It's only going to hurt you. So if someone has questions about both family and criminal law issues, how should they prioritize seeking help?
So
I know what I would tell them. I would probably tell them, you need to go, if you can't afford to hire 2 lawyers, you need to go get a criminal lawyer.
I say definitely speak to especially with the fact that your custody case may be stayed, but you do want to speak to a criminal defense attorney. I would laugh because a lot of us may not, don't necessarily charge for consultations, where for civil attorneys, you may, if it's not an injury case. But I would say, because it can affect your housing, it can affect your custody already, it can affect your employment. Right. Definitely that. I mean, there have been times where, once someone's charged with something, even though they're not convicted, sometimes they are evicted from their apartment. They lose their job, and then that can affect their ability to be able to, deal with their custody issues and pay for their attorney for their family case and deal with other issues that come up.
That's a great point. Yeah. Well, what's one piece of advice, if you could pick one, that you wish more people knew about criminal law as it impacts families?
So I think we kind of touched on it before, with people trying to kind of do their own negotiation outside of the court system, and how either it's often unethical, but it also can make things a lot worse. I think usually just complying with court orders and letting the process work on its own. You'll have your day in court. You'll have representation. You'll have a chance to put everything out that needs to be put out on the record in front of the judge. But trying to, negotiate or use third parties or, use threats, things like that are not going to end well. So let the system, do its thing and follow the process. It may take a while, but that is going to protect both sides.
Yeah, and let your lawyer do their job.
Right.
Right. That's a great point. Well, thank you so much for joining me today and sharing your insight about criminal law and family law and where they overlap and intersect. I think this is one of those conversations that really highlights how important it is to get the right guidance early, especially when so much is at stake for families. And I don't know if we really said this, but when in doubt, just keep your mouth shut.
Yes.
And thank you again to our listeners for tuning in. If you're facing a family law issue and you aren't sure how other legal matters might impact your case, speaking with an experienced attorney can make all the difference. We'll be back soon with another episode of Herlihy Family Law. Until then, take care.
Thank you for tuning in to the Herlihy Family Law Podcast. Remember, you don't have to face family law challenges alone. Visit HerlihyFamilyLaw.com or call 251-432-7909 to learn more.